Good afternoon, everyone. My name is Doug Maurer, and I am the Executive Director of the Georgia Justice Project. And welcome to this webinar about the new bill, SB 105, around terminating your probation or terminating probation early. And we are so excited to have you here today. So I want to just give you a quick overview of what we expect to happen today in this hour. First, I'm going to just cover some things about the Georgia Justice Project. That's who I'm with. We have a couple slides about that, but also a slide about the criminal justice system largely writ large. Then we have a few guest speakers who are with us, one by audio, two in person. And then we're going to dive more deeply into the probation system in Georgia and ending, of course, with the digging deep into SB 105 and how this new bill works. Well, we're trying to save about 15 minutes at the end for questions and answers. So please be ready with that. We have our team who's online ready to answer as many questions as we can. But for Q&A, please use the Q&A feature and not the chat feature, if that's okay. So the Q&A feature at the bottom of your screen is the best way to sort of queue up your questions. And before I start, let me just thank our team here at the Georgia Justice Project for all your great work in pulling this together. Thank you. Okay, so let me just jump in. The Georgia Justice Project, we are a 35-year-old nonprofit organization. We're located in the Old Fourth Ward here in Atlanta. We are about a $2.5 million budget or so. All of our funding is totally private, and that's the way we've been since we started. We have about 30 or so staff, almost 30 staff, with some being part-time and the bulk being full-time. And we also use a lot of volunteer lawyers, particularly on our criminal records area. So last year, I think last fiscal year, we had about 150 lawyer volunteers helping represent clients and do intake and pardon and parole matters with regard to our clients. So this is a quick overview about who we are as an organization before we jump in. And next, I just want to talk about the criminal justice system really here in Georgia. And I always talk about the system, as many people do, in sort of three buckets, sort of front end, middle, and back end. And front end is anywhere from policing all the way through the court system, if you will, and sentencing if it happens. And then middle is, of course, incarceration, most folks think about. And lastly is sort of reentry, the blue part of the graph here you see. And reentry includes probation and parole, but also those who are totally not under correctional control, those who have a criminal record and are trying to reenter society. And the numbers at the top of this give you some perspective for Georgia. So in Georgia, there's about 90,000 people who are currently incarcerated, and that's broken up there with the majority being in prison and the other chunk, about 40,000 folk who are in local jails awaiting trial or under misdemeanor sentence. But the green part there is important, and it's really relevant to what we're going to talk about today, is those under correctional control. And this, the correctional control is defined by probation or jail, prison, probation, and parole. So if you are in jail or prison or on probation or parole, you're under correctional control. And that number for Georgia is about 527,000 people, and 1 in 18 folks in Georgia are under correctional control. It's the highest in the country, and it's sort of one of the main reasons for why this bill, and we push for this bill, and why this is important. But also we want to say that in our work, which I'll just give a couple nods to in a minute, over the last 35 years, we have, because we follow our clients all the way through the system from beginning, from the red part all the way through the blue part, we have known about how difficult it is to sort of be successful on probation, particularly, and how long probation sentences are in Georgia, and how difficult that route is. And so this bill is really addressing that concern that we've seen for years, and many people have seen. And so we're terribly excited about it, and terribly excited about the launch of this bill and how it will affect many, many people. So the next slide really talks about GJP, Georgia Justice Project, and who we are and what we do. The thing we've done the longest, I always say, is when it starts in this red portion, this holistic criminal defense. And what makes that work really unusual is that we follow our clients all the way through the system. And that's, we have lawyers and social workers who do that. And again, it's not court appointment, it's not government funded, it's all privately done. We show up in the middle part of this graph as well, certainly about following the first chunk of clients in, but even more recently, we've been working with this new prison in the state called the Metro Reentry Facility, MRF for short, which is the only Department of Corrections prison inside the perimeter here in Atlanta. And it's a tremendous, experiment really, and a wonderful effort by the DOC to really get people ready to reenter. And we've been out there representing people, helping them overcome barriers before they get released, reentry barriers. And one of our social workers is working, helping them land jobs and supporting their job search as they get out. And then the blue part, this is probably the biggest part of our work, and more people know us for this, but for the last 15 years or so, we help people really overcome the impact of a criminal record, and mostly through expungement and other mechanisms, working with expungement summits. We're very excited launching our first expungement desk in a few weeks up in Cobb County, in the ways we're showing up around the state and have been for a number of years, helping people overcome the impact. And then, of course, the last part I'll say is really why we're here today, and that's policy. We work on the policy arena, and that's sort of the green arc on the outside of this arc. And for the last 12 or 15 or so years, 13 years, we've affected about 21 laws, and 2 of which in the last 12 months we're very excited about. First was expanding the expungement bill and the expungement law that went into effect in January of this year. We'll make some quick reference to that, but obviously we're here today about the new bill around probation and SB 105 and early terminations of probation. So that's just a quick overview of who we are and some of our sort of orienting you to how we show up in this space. Okay, with that, I want to introduce electronically Senator Brian Strickland. Senator Strickland could not be with us personally today, but he did do a recorded message. I want to say a couple things about him before we play this message, which he's very gracious to do. He is from McDonough, Georgia, and he authored and championed SB 105. He is currently chair of the Judiciary Committee in the Senate, where this bill began. He has served in the Georgia legislature for 8 years and has held numerous key leadership positions in both the House and the Senate, including being the floor leader for Governor Kemp. And we greatly appreciate his vision and his compassion and leadership with regard to addressing this issue about allowing termination of probation here in Georgia. So with that, we'll roll the tape.
Thank you, Doug and Lisa, Rachel, everybody at Georgia Justice Project. Thank you so much for putting on this webinar and everyone for joining this event today. I've really enjoyed over the past month after we finished the legislative session getting to travel around and talk about the story of Senate Bill 105. It's important because I want to give credit where credit's due. The Georgia Justice Project came to us last fall and said, we have a problem we've identified. Georgia has more people on probation than any other state in the country, not just per capita, but total. And digging into this, we realized something as so simple as an old law we passed several years ago was not being followed. The process was too complicated, and the way we set it up was just not working. And they told us you have over 50,000 people in your state that currently are sitting on probation, yet they shouldn't be. These are folks that should have their probation terminated. And we learned in digging into all this, the state is spending over $30 million a year supervising people that should not be on probation. So I give credit where credit's due. I love telling the story about Georgia Justice Project bringing this issue to us as legislators. And then I love telling the story about how legislators came together, both sides of the aisle, and made this bill a priority. Senate Bill 105, when I presented it on the Senate floor, what I said, I think, is very true today. I think there's no other bill that's more consequential this past session than Senate Bill 105. You look at the lives that this bill is impacting right now in Georgia, the lives will be impacted down the road in Georgia, all those folks that get that second chance, a chance to get back into society and not just get into a cycle in the criminal justice system, get a chance to go out and get their first home, rent a home, go get a job without having to tell their employer, their landlord, they're on probation. So it's a great story in that sense. And of course, from a financial standpoint, looking at the tens of millions of dollars that we can save at the state level or divert towards those who actually need to be supervised as well. And so I love telling the story for those reasons about Senate Bill 105. But I think most importantly now, as you're doing here today, it's important that we get this out to the citizens in our state. I appreciate the work of DCS, and I know that they're taking part in this event today as well. We have to make sure that we get word out to everyone in our state, from those that have been charged with crimes, of course, the lawyers who defend people that are charged with crimes, to our judges that are out there, of course, employees of DCS as well, to make sure that everyone knows about this law, to make sure this law can be followed so our citizens can take advantage of this. So sorry I couldn't join you guys in person today, but thanks for the opportunity to give this message in advance. And thanks once again for all the work that you all are doing to help people in our state.
We so appreciate Senator Strickland giving us that message. He's been, just a tremendous asset to the state on this issue. But also, there's another person we really need to lift up and have you meet today who co-authored this bill in the House, and that is Representative Tyler Paul Smith of Bremen, Georgia, which he carried this bill in the House. And he is a criminal defense lawyer at the Perry firm, and he's known the need and seen the need for this kind of relief in Georgia. He's a first-term legislator, so carrying this bill, SB 105, was his maiden piece of legislation, and we appreciate his choosing probation reform as his first big issue to lead on and champion. So with that, Representative Smith.
Well, good afternoon, and thank you for those kind words. And I just want to first off start out by thanking everyone for the hard work. I really got the easiest part of the whole deal by getting this through the House. And thank you to Senator Strickland for his hard work. I know Ed Lindsay had originally brought this legislation to me, and we had basically the same version over in the House, but thankfully they were able to get it out of the Senate a lot faster than what we probably would have been able to in the House. So it's been a pleasure. I have been involved in criminal defense work since I was sworn in to practice law. And although I haven't been practicing very long, I was thrown into the criminal justice system from the get-go. And so regularly handling probation issues, revocation of probation, dealing with pleas that involve probation time. So you have to really learn the ins and outs of our probation system here in the state of Georgia in situations like myself and others have found themselves in. So this was something that became near and dear to me. And I was really thankful to have the opportunity to shepherd this through the House. A little bit of an interesting situation. I come from a very conservative district. And so I was trying to, drum up support for the bill and talking to people about the bill. They were curious about it, other members were. And criminal justice reform seems to kind of be a little bit of an interesting topic for certain legislators. They're afraid of it. And I told them, I said, look, from the district that I come from and being associated with criminal justice reform, it's not a taboo topic for us. I know that the initial changes to our probation system were accomplished in 2017, specifically with early termination of probation. And we've then seen a change in administrations. And I'm thankful that Governor Kemp signed it. I know we were probably all wondering if the governor was going to sign this with his stance on issues in our criminal justice system. So I was very thankful that he stepped up to the plate and saw the need for this. And it really wasn't a hard sell for us in the House. All the groups working together on this bill really put at ease any issues that anyone may have had come to mind. And so grateful to be a part of this, and just, I hope it's not lost on everyone that believe the figure was 24% of those on supervision. Once this bill was signed into law by the governor, they qualify to be taken off of direct supervision. That is huge. It's clear that these individuals are not the ones that we feel like should be, from a policy standpoint, still on direct supervision. So we're marshaling our resources at the Department of Corrections in a manner where we're actually supervising those that need it. And so learned a lot from the process behind the scenes. And, going forward, I just hope that judges, that I know in talking with some of you, I noted that there are a few judges who understood how this was supposed to work, but this providing the clarity and the consistency across the board, that's a huge step. And so no one can be confused now about what their job is from at least the judge's standpoint, prosecutors, and defense counsel. So just thank you again for the opportunity to allow this to be my first. I hope I didn't disappoint, and look forward to working with y'all in the future on issues.
Thank you, Representative. No, this, I'm sure it will not be it might have been the first, but we're sure it won't be the last. So thank you for all your help and all you're doing. And next, we're really honored to have someone who, from the DCS, Department of Community Supervision, Scott Maurer, who's the Assistant Commissioner. And Scott is a friend, and we've worked a good bit with the DCS over the years, and it didn't held up during this process as well. And Assistant Commissioner Maurer has worked in criminal justice really for the past 18 years. He's had various leadership positions, both with the State Board of Pardons and Paroles, as well as the Department of Corrections, and now with the Department of Community Supervision, where he runs all of DCS along with Commissioner now. Scott is a lifelong public servant whose deep passion for his work has led him to be recognized as an innovator and a visionary in the field of community corrections. So with that, Scott, I will turn over to you, and maybe we have a few questions, but let's start with however you'd like to jump in.
Sure, thank you, and certainly appreciate the opportunity to be here today. You know, the Department of Community Supervision was created almost 6 years ago, and it took the felony parole supervision and the felony probation supervision from the entities that it used to be under and put them under one agency. And, you know, since our inception, there's really been two, what I would say are the major obstacles to us being able to focus our resources on the people that are at the most need for them and at the highest risk. And Doug, you've done a good job covering some of them, and so has Senator Strickland and Representative Smith. But for those of you who don't know, just a little bit of background, really the first large obstacle for us is that there are over 200,000 people under felony supervision in Georgia. And that number is far too high. It's one that we're certainly not proud of. And it's one that we have looked for ways over the past 6 years to reduce. And the second one, and I know this is something you'll be talking briefly about later, is that the length of time people are on supervision in Georgia is far too long as well. So you have two things kind of working against us. One is there's too many people under supervision, and the second being that the sentences for their probation term are far too long. So in Georgia, it generally averages about 6.5 years for a probated sentence or a probation sentence. And so those are things that we have faced as an agency as obstacles since our inception. And this bill has the potential to have a significant impact on both of those areas. And one of the things that it does that the previous legislation didn't do is it simplifies the process. It simplifies the criteria for early termination, and it certainly streamlines the process. And it does have the potential to have an enormous impact on the number of people under supervision. So I would just want to personally thank you, Doug, and the Georgia Justice Project, as well as Senator Strickland and Representative Smith for your work on this bill and helping our agency address these obstacles. The criminal justice system as a whole has many opportunities for improvement, but it really does require some strategic initiatives and strategic partnerships. And it takes an effort of people from many different entities and stakeholders in order to accomplish, you know, changes such as this that can have such a meaningful impact. And I think this bill certainly has or is a great example of what we can accomplish when we're all working together for the same cause. So again, I appreciate the opportunity to be here this afternoon and appreciate all the work that you've done with this bill.
It's our pleasure, and it's so great to have you. And I just want to, I know just for a question or two, but let me just ask, is there anything you want to share about how DCS is sort of going to implement this, or a prioritization of sort of rolling this bill out and how it's going to show up in communities?
Yes, so that's a great question. So when the bill was signed, we put essentially two separate processes in motion. And one of them is an automation process. And it's very similar to processes that we put in motion for previous legislation. And it uses our database to comb through data on a nightly basis and look for criteria and then serve that information to our officers in what we call a what's next queue. So essentially an electronic process to notify an officer that, you know, these people under supervision on their caseload have met the criteria for early termination, whether it's bid date, early termination, or what that means is. And so right now our IT folks are developing that process And we have a firm target date of July 1st to have that infrastructure set up so that officers can start receiving electronic notifications of people on their caseload that meet the criteria for early termination. The second piece of that is, I think one of the things that makes this bill so unique is that it's retroactively applied. So it's not just going forward, people that get put on probation are eligible for early termination at their bid date or at the 3-year mark or whatever it may be. It's going to be retroactively applied to everybody currently under supervision. And so the second piece of this is generating reports to identify those people that are currently under supervision that already meet the criteria and have not been early terminated, and then making sure that they're put into that electronic process flow so that we can do the next steps that are required in order to send our order to the court to early terminate those cases. And so that process as well, that process is also scheduled to be right now, July 1st. And so as of July 1st of this year, we hope to be starting to see some movement on cases being generated and targeted and identified as being eligible and starting the process of that early termination process.
And so just one last one, if I might. So for folks who are listening who might be wondering, what they should do, if anything, what was your advice for them to reach out if when they hear the qualifications? We'll come up in a minute and how the bill works. Should they reach out to the probation officer if they qualify, or should they wait until after July 1st to see how the system is going to roll out?
So the first thing I would say is we encourage anybody under supervision to always communicate with their community supervision officers. So there is nothing that prevents them from contacting them early. As an agency, we send out legislative updates, and we've also sent out some fact sheets about 105. And so there's probably officers that are already doing the manual comb through of their caseloads to see if anybody meets the criteria, because it benefits them to be able to early terminate those people that are compliant and meet the criteria. And so if there are people that know that they meet the criteria and want to reach out to their officer, we would never discourage them from contacting their officer for something like that. So now we're expecting there to be a huge number of cases right off in the beginning that we're going to have to process. So that's going to take some time to be able to process those cases and then get those orders to the court and give the court the 30 days that they need to, schedule a hearing if they're going to schedule a hearing. And then, so that whole process takes a little bit of time. But no, I would, if people that are under supervision feel like they meet the criteria right now, I would certainly encourage them to reach out to their community supervision officer and see if they meet the criteria first. And then that at least will notify that officer to kind of start the process for those specific individuals.
That's great. That's very helpful. Well, before we go to the next area, and I pass off to one of my colleagues, is there anything else you wanted to share with folks listening today?
So the only other thing that I would add to that is that there are, and I think that one of the questions that you guys had sent me ahead of time was about people that are out of state. And so if you're out of state, you probably more than likely as an out-of-state person under supervision, you're probably not aware of who your case is assigned to. And so for those people, what we would do is we would encourage them to call our call center. That number is on our website. I can give it to you quickly too, if anybody wants to jot it down. It's 678-783-4337. And so they can then call our call center, and those call handlers can then identify who that case is assigned to if it's an out-of-state case, and then the process can start working from there. So not all of our offenders, while the bulk of the offenders are under supervision in Georgia, not all of those under supervision are in the state. So that's just an easy way for them to contact us and see if we can be of assistance to them. That's great. That's very helpful. We'll make sure and post that as well. But thank you, Scott, so much for all your hard work on this. And again, we appreciate all the work you're doing, and we appreciate the partnership we've had with you all for so many years. Sure. Thank you, guys. All right. All right. Well, with that, I'm going to pass the ball here to Lisa Mcgann, who's our policy director, who's going to pick up and move this process forward. I want to again thank all of our great team, some of whom you'll see today, most of whom you won't, who are behind the scenes, but thanks for all your help in making this happen. And with that, Lisa.
Good afternoon, everyone. Thank you, Commissioner Maurer. And as Doug mentioned, my name is Lisa Mcgann, and I am the policy director at the Georgia Justice Project. And I am happy to see so many people at this event. I will spend a few minutes describing probation in Georgia. why there was a need for reform, and what we still want to accomplish in the years ahead. And Commissioner Maurer helped out a great deal by already addressing some of this. So what is wrong with probation in Georgia? Simply put, we have too many people serving unnecessarily long probation sentences. Georgia has more individuals on probation than any other state in the country. Over 400,000 people are serving either misdemeanor or felony probation. Half of those are serving misdemeanor and half of those are serving felony probation. And to give you some context, this is about 300,000 more individuals than in California, which is our most populous state in America. A big reason for these large numbers, as Commissioner Maurer said, are the long sentences that individuals are given. While 36 states cap probation at usually 2 to 5 years, Georgia does not. 40% of all probation sentences exceed 10 years. So you can see just how dramatically we lead the nation in terms of all correctional control. But if you focus on the red line specifically, that is probation and parole, the red line, you'll see that on a per capita basis, we have more than twice the number of people serving probation and parole as every other state in the nation. In addition, there are huge racial disparities in our criminal justice system. Unfortunately, this is a systemic problem in every state, not just Georgia. But you can see that in all 159 counties in Georgia, Black individuals are at least twice as likely to be supervised as white individuals. Here in Fulton County, that number is 8 times more likely. And in some counties in Georgia, it is high as 9 times. And finally, it was imperative that we had probation reform because we know that long sentences do not help Georgians. State and national data show that longer probation sentences do not decrease criminal behavior. Over-supervision, in fact, has a punitive impact, and that is what actually increases criminal activity. New offenses predominantly take place in the first 2 years of probation. There is no public safety benefit to having long probation sentences. Instead, it diverts resources from necessary safety needs. Longer sentences also drive technical violations. And a technical violation is breaking a rule of probation, not breaking the law. We can trap individuals in the criminal justice system for years through these violations, and they cost taxpayers millions of dollars every year. So while there is still work to be done, still more probation reform needed in Georgia. For instance, probation caps, like so many of our sister states have, eliminating split sentences, resolving detainers, and reducing technical violations. This new law, SB 105, will allow every individual serving felony probation access to early termination after 3 years if they meet certain milestones. It is a first and very meaningful step towards reducing the number of individuals serving felony probation in Georgia. And with that, I'm going to pass it along to my colleague, Rachel Holmes, managing attorney at GJP, to talk about the specifics of this new law. Thank you, Rachel.
Thank you, Lisa. And like Lisa said, I'm very excited to have so many people here to learn about SB 105. But now that SB 105 is passed and it became effective on May 3rd, it's time to start the real work, and that's getting people off of probation. Georgia Justice Project has been representing individuals and advocating for early termination. But with SB 105, you can advocate for yourself. We hope that everyone leaves this webinar knowing what you need to do to accomplish what to get off of probation early and how to start that process. you've already heard this statistic, but according to DCS, 1/4 of the people on probation are eligible for early termination under SB 105 right now. And we think that number will just continue to grow as people learn what they need to do to get off of probation, and continue to hit those 3 years that is necessary before you're eligible for early termination. So what does SB 105 do? It creates a clear criteria, one court process, and one court standard for everyone to have access for early termination. Several people might say, okay, I know there was this bill back in 2017, there was already some probation reform. So why is SB 105 really needed? Isn't there already a way for people to get off of early termination or get off of probation early? So for that, what we want to say is look at this chart. All right, so this was how, before SB 105, the process for early termination. As you'll see, there's 3 different pathways, and you'll see that each different pathway had a different criteria for eligibility, a different court process, and a different court standard. This made it very confusing, very complicated, and meant that people were not able to access early termination. During our work with our criminal defense clients, as well as our reentry clients, we started to see how difficult it was to get our clients off of probation. And we started to realize there was real need for reform. And during this digging process and during speaking to different probation officers, going to court and advocating for early termination, we really started to see one of the main issues that we were seeing was that what was happened back in 2017, which is called a behavioral incentive date, and it allowed a certain group of individuals to get off of probation early, wasn't working. And DCS came out with the data last fall that said over 50,000 people, about 50,000 people should have been eligible for a behavioral incentive date. And as of last fall, only 213 individuals actually received early termination. So we can see that wasn't doing what it needed to do. It wasn't getting people off of probation early. So while we started digging into that and looking at that, we said, okay, we need to do this, and what can we do to make every single person eligible? And that's when we expanded what we were doing in our criteria process and the court standard. And with that, with SB 105, everyone is eligible to be considered for early termination after 3 years. So SB 105 creates an early termination pathway for nearly 200,000 individuals. And this will allow you to know what you need to do to get off of probation early. So let's see what SB 105 did to that confusing chart. All right, so now we still have the 3 different pathways, and those are still part of the law, but what it did is it allowed a clear criteria for eligibility, as well as the clear process and the clear court standard. And I will talk about all 3 of those pathways in a little bit. And we'll go through each one of those and then the different ways you could possibly fall into one of those pathways. But what I want everybody to understand is that either way, you fall into one of these 3 pathways. And that's the important part of SB 105, is that now everyone flows into the same criteria, the same court process, and the same court standard. And we're going to go through each one of those because that's what I want people to understand. I want people to have the knowledge of what do I need to do to have the best chance of getting off of probation early. So we're going to talk first about their criteria for eligibility. And so what that criteria for eligibility is no arrest for anything besides a non-serious traffic offense, no probation revocations in the past 24 months, and that you've paid all your restitution. And this is specifically restitution, not including any fines or fees. So first, we're going to talk about the first one, no new arrest. And it does mean no new arrest. So this means no, you've not been arrested for anything besides a non-serious traffic offense. And we have listed what is considered a traffic offense in there. So if you've been arrested for something, one of those serious traffic offenses, or if you've been arrested, unfortunately, you're not going to be eligible. But we are going to talk about ways that we are still going to be advocating for individuals and ways that you might be still advocate for yourself to get off probation if you have had an arrest, especially if that did not result in a conviction. But the first criteria is no new arrests since you've been on probation. The second one is no revocations in the past 24 months. So this means the last 2 years that there have had no revocations. And I really want to dive into what is actually a revocation. So a revocation means that your probation has been revoked in whole or in part for violating a condition of your probation. But this means that you were actually sentenced back to some time in custody. So this means that does not mean that there was a modification of your probation conditions, not that there was a sanction, not that a status hearing, but that you were revoked, some amount of time was revoked and you were put back into custody at some point in time. And I think it's really important to know the difference here. And it's really important for you to know how to, when you're talking to your probation officer and you're going through probation, to know what is a revocation and what that means compared if it's just a sanction or if you have to have a status hearing. And one of the things I will say, was speaking with several individuals and lots of my clients, is sometimes something is happening on probation they're not able to complete. And that might be an inability to pay a fine, not completing the community service at the right amount of time they were supposed to because of a job, not completing the class they were supposed to because they had to work or they didn't have the money for the class. And all of those actually are reasons to talk to your probation officer, okay? So a lot of times when that happens and people are not completing what they're supposed to do, they don't go to probation because they're scared they're gonna get revoked, and they're scared if they walk into probation, they're gonna get arrested. And of course, I can't say that's not gonna happen, but what I'm saying is if you talk to your probation officer, what might happen is it could be a sanction, it could be a status hearing. But what I will tell you, what will happen is if you stop reporting to probation, there will be a probation warrant put out for you. There will be a failure to report will be put out, and that will be your probation revocation. And once there's a warrant out, then you're arrested. And once you're arrested, you're in custody, which means that most likely this will resolve in a revocation. So that's why it's very important. I always tell all of my clients, I tell everybody, please just report, and just report to probation. Stay in contact with your probation officer. If they say that you need to report and you haven't done it, if you show up, you can, maybe they'll take you in front of the judge. Maybe the judge will sanction you. Maybe they'll give you more community service. You might have a curfew, but those are not a revocation. A revocation is if you have been in custody, but if you have a warrant out for your arrest for failure to report and you're in custody, and if the probation officer comes and gives you a consent order just that day to get released, it still is a revocation of some amount of time, the time that you've been in custody, and therefore that would include a revocation. And so I want to make that distinction because this is something that you would just strive to anyways, but definitely strive to when you're trying to do your early termination is you can go 24 months without a revocation. The third thing that you have to do is you have to pay all your restitution. And this specifically does mean just restitution. This is something that changed. It is just paying all of your restitution. This is not fines. This is not probation supervision fees, and this is not fine surcharges. It's just a couple of the things that people might be aware of. This means it's a restitution. This is something that was court ordered, that the judge court ordered you to pay to make a victim whole. And we have spoken to DCS about this a lot, and really what they say is there's only about 6,500 individuals that that have a restitution, and only about the average is usually only about $500. So please, this is something for people to continue to work towards and to try to get off of probation early by paying off the restitution. So you're past the 3 years of probation. You've hit all of the eligibility requirements. What is next? Next is the court process. And again, no matter where pathway you are, the court process is the same. So once you are eligible, DCS will then submit an order to terminate to the court on your behalf. And this will go to the sentencing court. And I think this is a distinction to note because if you have transferred your probation or if you, and by means that is that if you were sentenced in one county, but you're actually being supervised in another county, you have to go back to the county that you were actually supervised in. that you were supervised, that sentenced you to have your probation terminated early. So once the court receives the order, then the judge must grant that order unless the court or the district attorney requests a hearing within 30 days. And so once the DCS submits the order, then they have the 30 days to request a hearing. So again, we've got a must meet criteria for early termination, all three of those, then an order is submitted. And if if the court or the district attorney does not request a hearing within that 30 days, then the judge must sign the order, which would terminate your probation, and that would mean that you were off of probation. So let's talk a little bit about what is the standard that the judge is considering. So now this is a standard for all of early terminations, but it's most relevant when there's actually a hearing. So if the district attorney or the judge sets it for a hearing within that first 30 days, then it will be scheduled within 90 days of them receiving that original order. And so during that hearing, though, the court is going to take whatever action it determines would be the best interest of justice and the welfare of society. And so this is a hearing where you would have the opportunity to really advocate for yourself. And so we've gone through the entire process and we're at the bottom. And this is the first time that I mentioned this might be if you get scheduled for a hearing, this is the first time I would say you might need an attorney. And this is something that GJP absolutely is hoping to represent people in Metro Atlanta, or you could hire an attorney, or you can advocate for yourself. We are hoping to have future webinars and videos that will show and help educate you on how to advocate for yourself. But when you're at this hearing, you want to show the judge that you're stable, right? You want to show that there's any rehabilitation and show that you no longer need supervision. So I know that there's a lot of people that are probably on non-report, right? So if you've already been on non-report, DCS has already said that they don't need to supervise you, right? So now we just need to prove that to the judge. And some things you can do to help prove that is showing that you have stable housing, stable employment, your family lives, if you've gone in through any treatment, if you've furthered your education, anything that just shows how your life has improved since you were originally on probation, that you no longer need any type of supervision. That is what the court will be looking for at that time. But again, this is something that GJP is hoping to help you. If you get to this point, please call us and we would like to advocate for people at their hearings. So next, we're going to talk about, we've talked about the criteria for eligibility. We've talked about the process. We talked about the core standard. And again, everyone flows down to those, but we're going to spend a little bit of time talking about each of those different pathways and see which one of those you would fall into. I know I've said it plenty of times, I'm saying it again, but this is really just for you to have the knowledge. This is for you to advocate for yourself when you're talking to probation about, and somebody says, well, what about, do you have a qualified offense? What do I have this? This is just for you to learn to advocate for yourself in this scenario, but you still come down to the same criteria, still come down to the same court process and still the same court standard. But we want everybody to kind of understand, because this is words and language that you're going to hear and you've heard throughout this, and we want to go through each of those individually. So the first one, which is what was enacted back in 2017, is a behavioral incentive date. So who is eligible for a behavioral incentive date? So that is if it is your first felony conviction, or you're under a first offender sentence, or a conditional discharge sentence, and you were sentenced to serve less than 1 year. And so this is a very clear criteria: first felony convictions, first offender, and you were sentenced to less than 1 year to serve. So if you fall into that, you're eligible for a bid date. So when is your bid date? And as Assistant Commissioner Maurer stated, this is retroactive. So if you fall in that first category, your behavioral incentive date is 3 years from your sentencing date. And this is really important because this is part of the issue of why bid wasn't working, is people were not actually getting a behavioral incentive date when they should have gotten one. And what this does is that removes needing to be a part of a sentence. This removes any of that question, and everybody that falls in that category would have a behavioral incentive date. But with a behavioral incentive date, unlike any of the other two pathways, unless it's part of your sentence, but in behavioral incentive date, that a sentencing judge could put in your sentence that giving you a behavioral incentive date of less than 3 years. So you can see in your sentence date, a year of 2 years until a behavioral incentive date, or 18 months. And what that does is that moves you quicker through those top 3 that we're looking for, quicker down into the eligibility criteria, moving you through the process. So that's what that would do. But again, if not, same as everybody else, you would have specifically called a behavioral incentive date instead of early termination, but that would be 3 years from then. So let's say you don't, it's not your first felony conviction, it's not first offender, or you were sentenced more than a year to serve. What are the other pathways? The next one is it could be a qualified offense. So this is under OCGA 42821, and there's 17 qualified offenses. We've broken them down to kind of including the theft offenses includes everything from a theft by taking to theft by shoplifting to theft by receiving, and including all the drug offenses as well as in one. But these are the 17 qualified offenses. And if you have one of these qualified offenses and you don't apply and you don't qualify for bid, same scenario though. You go 3 years of probation, you meet your criteria, and then DCS must submit an order. So once you have met your eligibility criteria and you've been on probation 3 years, DCS will submit that order, and it will go to the judge, and the judge can sign that order. It can be set for a hearing, but hopefully the judge will just sign that order, and you would be off of probation at that point in time. So let's say you're not bid. It's not your first felony of conviction, but you're also not one of these qualified offenses, then you land in the third pathway, which is all other offenses. And what I want to say about this is, again, it's the same criteria, it's the same court process and the same court standard. But what it does is before SB 105, DCS had to submit a progress report for every individual that was in this pathway. But what we did is we changed that progress report to include all the different criteria that is the same for all the other pathways. And so what that means is in that progress report, they must specifically state whether or not you've been arrested, whether or not you've had your probation revoked in the last 24 months, and whether or not you've paid all your restitution. And it's the same eligibility. So if your progress report says you've completed all that, then they will recommend early termination. And again, the change here is SB 105, they will now submit an order with that progress report. So instead of just sending a progress report, now with SB 105, they will submit an order, and then it'll go through the same court process and the same court standard. And that's what's really important in that. Now, also, since they were already doing this annually, if for some reason after the 3 years you have had a revocation the first year, or you're still working on paying off your restitution, they will annually submit these written orders that or written progress reports until you have before you've completed all your eligibility, and then there's the order to terminate that will be sent along with the progress report at that point in time. So those are the 3 different pathways. But one other thing that SB 105 did is we created a catch-all. So this is, if you file a motion to terminate your probation at any time, you will have the same court process and the same court standard. And that means that you will be scheduled for a hearing within 90 days of filing the motion to terminate your probation. Here at GJP, what we expect to really be doing that the most is to enforce motions to terminate, as well as to file motions to terminate if, say, unfortunately, somebody was arrested, but it did not result in a conviction, and we still want to advocate for them. And still, of course, we believe you should get off of probation. And this is another pathway that we could go through, another process that we can use to file a motion to terminate, and then there would be a hearing set within that 90 days. So I know I have given everyone a lot of information. I do want to leave some time for us to answer some questions. There's a lot of participants, and I apologize, we're not going to be able to get to everybody's questions, but I do hope we can provide some further clarification. And to do that, I'm going to bring in DJ Sims. He is our criminal record specialist and our reentry organizer, and he's going to moderate the questions and answer portion for us. I will be staying for that, as well as Elizabeth Rainwater, our staff attorney and equal justice work fellow. She'll be joining to help me answer some of the questions for everybody. Thank you so much.
Thank you so much, Rachel, for that introduction. And we want to go ahead and jump right into a couple of guidelines for the Q&A, because we want everyone to, this is a chance for everyone to participate. So feel free to put any questions you have into the Q&A. We have folks monitoring, and we also want to look for common themes. As Rachel mentioned, we won't be able to get to everyone's question because we have so many people here, which is awesome. But we will provide information on how you can reach our office with specific questions regarding any questions you may have specifically about your situation. Our first question for today, Rachel, you started off this conversation talking about advocacy and a way to advocate for yourself. So could you elaborate a little bit more on, do I need an attorney to get my probation terminated under this new law? Or when would be a situation when I would need an attorney?
Yeah, no, absolutely. For SB 105, that was one of the things, is you do not need an attorney to start this process. This is a process that will be started by DCS. And as you heard, they're already started, and they're getting everything, their technology in order to be able to send these orders in as soon as you qualify. So you will not need an attorney to start the process. This is not something that you will need to file on your own or have an attorney file to start the process for it. But with that being said, you might need an attorney if you do have a hearing scheduled. So there's completely a great chance that you go through the entire process without needing an attorney, without even you being involved in the process. But I would say to reach out to your probation officer, advocate for yourself for that early termination. And if you're unable to move the process forward, then I would say to contact us or contact an attorney. And if you are scheduled for a hearing, or if you think that you're being denied when you should be eligible, then that's when I would reach out to an attorney. But you can absolutely go through this entire process without ever needing an attorney.
Awesome, thank you for that. Elizabeth, my next question is for you. Rachel did a wonderful job of laying out revocations. Could you talk a little bit more about what a revocation is? How would I know if I have one? Could you walk us through that a little bit more?
Yeah, absolutely. Well, hey, everyone, good afternoon. It's good to be here and to have you all here. So like DJ said, Rachel did a great job walking us through the whole process. I want to bring us back just to give us a bird's eye view of this again. Before I answer that, just to remind everyone, I know you've heard a lot of information about the process and the different pathways, but again, regardless of the pathway you're on, everyone is eligible to get their probation terminated once they meet these criteria. So again, you've served at least 3 years of your probation sentence and have no new arrests for anything besides a non-serious traffic offense. You have no probation revocations in the past 24 months, and you've paid all your restitution. So again, that does not include fines and fees. So I know you've heard that a lot during this presentation, but I just want to bring us back to that to remind us that this is really what we're looking at here to see if you're eligible for early termination under SB 105. But to get specifically to your question, DJ, a revocation, and again, Rachel mentioned this, but it's when your sentence is revoked in whole or in part. So this does not include a modification of the terms of your probation. This does not, if you got fines change or having to pay restitution changed to having to serve community service, that's not a revocation. Revocations typically result in jail or prison time. So we would not want you to think that you're ineligible for SB 105 because you had a modification or a sanction or even had a status appearance before a judge.
Thank you for that, Elizabeth. We're seeing some other questions that are coming up in the chat box. So I want to take a second about restitution. Rachel also mentioned restitution, Elizabeth. How do I know if I have if I have restitution that I owe, and how would I handle that?
Yes, so the best way to find out if you have restitution is to call your probation officer to check. You can also check your JPay account. If you've been making payments towards your restitution on that account, you can check and see if there's a balance remaining. DCS has actually shared with us that in some cases, individuals have even just 1 cent left of restitution. So it's really important, even if you think you paid it all off or you think you didn't have any, to call your probation officer and double check to make sure that you don't.
Thank you. Rachel and Elizabeth, we're getting a lot of questions about, people are concerned about how does this impact people who are on parole or people who have split sentences. Could you guys speak to that at all?
Yeah, absolutely. And so this is only for people that are on probation. So there is a different law that deals with people on parole, and that goes through the parole. The parole board, right? So that is a whole different entity, and that is not through the sentencing court. There is a way to get off of parole early, and that is going to be through your same DCS officer, but they will be requesting that, and that is a different criteria, and that is a different way for them to ask for you to get off of parole, and that is not here. So unfortunately, if you are on parole, you will have to complete your sentence solely on parole, and then you'll have to complete 3 years of probation before you would be eligible for SB 105. And I understand that this is difficult and I know there's people that are serving long parole sentences. And I would say if you are one of those individuals, you can reach out to us. We have considered those cases, and we can at least try to give you some direct advice on how to advocate to get off of parole early. So please do reach out to if that's something you want to consider. But there is, I would say, to speak to your DCS officer and ask them if they would finish your parole early, and then you would just start probation at that point in time. So it can be terminated, but SB 105 just talks solely about probation and not parole.
Again, thank you, Rachel. To kind of follow up on that, some people in the chat are a little concerned that this law is worse because of the 24-month period. Could you talk about why this law is better than what was in place previously?
I can take that, Elizabeth, if you want.
Okay.
Yeah, so this actually puts an actual clear criteria of what it is. Before, there was not a clear criteria. And again, we could go back to the very beginning, which I'm not asking you to do, Elizabeth, don't worry. Back to the very confusing chart. But in that chart, you see how there was different eligibility across them all. And one of the problems is with that is there was a subjective standard, right? So it was just saying whether or not that you have followed all of your conditions. And with that, we were seeing that people were not getting early termination, and we were unable to know why, right? So it just says you're compliant with all your general and specific conditions. So if you were compliant, then you might have had a status hearing, or if you were not compliant, sorry, you might have had a status hearing, you might have had a modification of your sentence, or you might have had a sanction, and you would not be considered compliant. But if you had one of those three things, that would not mean that you could still be eligible under SB 105 because you would have not had an actual revocation. And then another one of them just said, had you not had your probation revoked ever, was in one of the other pathways. So the criteria was different all across, and it was either a very subjective compliance, which might not happen, or it also said you never could have your probation revoked, and this makes it only 24 months.
Awesome, thank you for clearing that up. Another follow-up is, what next step should I take once my probation has been terminated? Once it's been terminated, what should I do?
Yeah, so I mean, and that's a great question. And as Doug has said, we do a lot of work in record restriction. And so one of the things we want to know is once you're done with probation, can your record be expunged? Can it be restricted and sealed? And it can immediately be restricted if you were on a first offender or a conditional discharge. And so if it was, your record would be restricted, but it would not be sealed, which means that you would still need to file something in the court system to get that record sealed. Those are the difference. Record restriction deals with your actual criminal history, your criminal record, considering like a GCIC. Your sealing, though, deals with what is in the court record. So it could still be showing up online or at the courthouse, and that could still be causing you issues. So you would want to get it restricted and sealed. Now, we also did passed SB 288 last year. And I'm sure hopefully a lot of you have heard about that. And that what it does is does expand finally. It's got a lot more work to do and we're going to keep working at it, but it does allow some felony convictions if you did receive if you do have a pardon to get off of your record. So if you were convicted of a felony 5 years after you completed your sentence and you receive a pardon, then you would be able to have your record restricted and sealed. But we are providing links in the chat to talk about expungement, to have an FAQ to learn more about SB 288. And then the first Friday of every month, we also have another webinar where we talk more about how to get your record clean and to possibly have an attorney look at your record and see. And I think these are very important things to do because you want to know what's on your record. If you're off of probation, let's see what the next step is. And the next step is seeing how much we can clear somebody's record.
Awesome. Thank you for clearing that up and laying out the process. And thanks for those links in the chat. Rachel and Elizabeth, one question that keeps coming up is about how does this law impact people who are on the sex registry?
All right, I'll go. So on the sex registry, and so unfortunately, this does not affect this sex offender registry, right? So this is just to getting off of probation. The sex offender registry is a whole nother initiative and a whole nother entity. And that was a whole nother process of how to try to get off the sex offender registry. Now, this can possibly get you off of probation, possibly get you off of probation early. And if you're on a first offender sentence, that could affect your registry. But that's a completely different entity that deals with sex offender registry. So unfortunately, this would not interplay with that unless this gets you off of a first offender probation and therefore would allow you to not have to register. And it also can get you off probation early, which could then start the process of how long you need to be off of probation before you can try to get off of the registry.
Thank you so much. Am I eligible to vote once I am off of probation?
I can answer that one. So the answer is yes, you are eligible to vote once you're off probation. You actually, if you are serving a probation sentence for under first offender or conditional discharge, or if you pled nolo, you can vote while on probation. But if you're not under one of those three categories I just said, you can vote once you're off probation, but you need to still go through the process of registering to vote. When you are discharged from your probation, we would encourage you to request a certificate of sentence completion and discharge. And basically what that does, it's a document that shows that your probation sentence is over. This is not a requirement to register, but it's a helpful document that can just show proof that you're no longer serving your probation sentence and are eligible to vote. We especially encourage people to ask for this document because if they're getting off probation early, because in the system, it might say this person's probation is supposed to be 10 years, but they were able to early terminate at 3 years. So again, we would encourage people to request for this certificate of sentence completion. There's a link at the bottom of this slide that can show you where to register, and I believe that is also going into the chat. And GJP also has great resources on voting that we will be sharing with you all as well.
And I would just like to really follow up on that certificate of sentence completion. And it is something that you can get from Department of Community Supervision. And you might also, when you receive that, when you get off probation, you might also receive a discharge from probation. And I would really advise people to keep that handy and keep that on you. That's going to be the way you're going to be able to prove that you're not on probation. People might be able to, until you get a restricted sealed, or if you're unable to get a restricted sealed, people might still be able to think that you're on probation, right? You might apply for a job and they're like, wait, you're still on probation. And the only way to be able to prove that is to have your order of discharge or have a certificate of sentence completion. So while it's extremely important for voting, I also think it's just extremely important you want to have that I mean, honestly, I would want you to have that if you get pulled over, and you can say, they said, this officer says you're on probation, you'd be able to show that you're not. So this is something that, since you're changing your sentence, I think it's very important to keep a couple copies of it and make sure that you have that with you.
Thank both of you for walking us through that. One question in particular someone has is, once a termination with a progress report is filed by DCS, and if denied by the court, who is responsible to begin the process of a hearing?
So I'm sorry, can you repeat that again? If it was denied by the court?
Yes, so if the progress report is filed by DCS, and if denied by the court, who is responsible to begin the process of the hearing?
Rachel, can you take that one?
Yeah, absolutely. So I think what this, and again, I hope that I'm answering this question correctly. So if an order is sent to the judge and the judge is like, I don't want to deny, I don't want to just grant this automatically, then the court must schedule it for a hearing within that 90 days. Or if a district attorney says, no, I don't think the person should get it, I request a hearing, then the court must request it. So there should be, before an actual denial of the order, there should be a hearing scheduled. So if they don't want to sign it, it should actually go to a hearing, and the court must schedule that hearing within 90 days of receiving the order. And if that is not what happened, that's a great example of why to reach out to us. That's exactly what we want to help with, is if a court system is not walking through the process and giving you the chance to advocate for yourself at a hearing, please reach out to us. But what should happen is, if the court is not automatically going to sign it, they should schedule it for a hearing, and it's up to the court to do that. But please reach out to us if that is not happening.
Thank you, guys. Just to kind of wrap up our time together, when would be a good time to reach out to Georgia Justice Project in order, if I need my probation terminated? When would be a good time to reach out to your office, and then we'll talk about how. So
Rachel kind of started saying this, but if the system is not working the way it's supposed to, so whether it was your order was denied and you didn't get a hearing, or whether the court doesn't move the order forward, that would be a good time to reach out to us. Also, if someone is eligible, they believe they're eligible under SB 105, but DCS is not submitting the order to terminate, then we would encourage people to reach out to us. But again, like Assistant Commissioner Scott Maurer said, we would also encourage you to first reach out to your probation officer and have a conversation with them. But if they're still not submitting the order and you believe that you meet those 3 criteria, then definitely reach out to us. And Rachel kind of hinted at this before during her presentation, but if you meet all the qualifications for early termination, but you have been arrested and that arrest did not result in a conviction, then we would also like you to reach out to us. Again, the criteria still says no new arrests since you were sentenced, but we would still want to see how we could help you with an arrest that didn't result in a conviction here. So do reach out to us in that instance. And then lastly, if your order gets scheduled for a hearing, so DCS submitted an order to terminate on your behalf, and you find out that that order is now, or that petition to terminate is scheduled for a hearing, then reach out to us because we would love to give direction or see how we can help advocate for you in that instance.
Thank you both so much. We'll stop our questions there, but again, this is not the end of the conversation. Feel free to reach out to us by email, and we will. I'll pass it for Rachel for information.
Yeah, I can close this out. Thank you so much, DJ, for everything, for moderating this and for pulling out some of those questions. I know that we could not reach everything, of course, but like we said, we are saying to advocate for yourself. And if you are running into any issues, do call DCS, call your probationer, ask for them. Just today advocating for a client, I was speaking to a probation officer and they're going to go up to the supervisor. So there's different levels. If you're told no, just say, I think I've really reviewed this. I think I'm qualified. What is the next step I can take? But please, if that is not working, you please contact us. We want to help as many individuals get off of probation Probation. We will be moving things forward. We do want to create a probation early termination, know your rights. So people will have a document that will be able to help them move through the process of early termination. I really am glad that so many people joined us for this webinar. Please sign up for our monthly newsletter. Please sign up for and follow us on social media. We have included our probation intake, which is probation@gjp.org. But there is also my email and Elizabeth's email. If you have any questions, please reach out to us. I'm very thankful that everybody joined, and I hope that we can get off as many people off of probation as soon as possible. Thank you so much and have a great day.